So all of us follow the Micula versus Romania case of the great excitement, because this is a case where we have a direct fight between the ICSID arbitration tribunal protecting investors' rights and the European Union protecting its own right, its own power to breach investors' rights. As I have already explained in my previous videos, the ICSID Arbitration Tribunal has entered an award awarding a compensation of 173 million British pounds approximately for the breaches of the Micula brothers' rights. They are Swedish investors in Romania, and Romania is a part of the European Union. It is a member state of the European Union. So the reaction, so basically Romania, in this case, Romania is punished for executing a decision of the European Commission, a decision of the European Union. So the reaction of the European Commission was to prohibit the execution of the award by Romania. Then the Micula brothers appealed to the General Court of the European Union. And in the meantime, there was another case of Dutch investors litigating against Slovakia. So in Achmea versus Slovakia, we had an award of the arbitration tribunal that is not related anyhow to the decisions of the European Union itself. It is a very local problematic. It is a very local case related only to the internal regulation in Slovakia. However, this Achmea versus Slovakia case went up to the Court of Justice of the European Union, and the Court of Justice of the European Union has explained that all the bilateral investment treaties concluded between two member states of the European Union are denounced from the day of entering of those member states, from the day of accession of those member states into the European Union. So we have already a judgment of the Court of Justice of the European Union saying that all those awards where an investor from the European Union wins a case against a member state of the European Union are not valid. And then what happens next? The Micula brothers continue their litigation. They want to get an execution of the award before the British courts. The first instance court of the UK stays the execution of the award in saying that there is a duty of a sincere cooperation with the Luxembourg court, and therefore the British court will wait for the judgment in the Micula case by the General Court of the European Union. And we know that the General Court of the European Union has a duty to follow the Achmea versus Slovakia judgment of the Court of Justice of the European Union because it is a higher instance. So Micula issues appeal, and the case comes before the English Court of Appeal. And the English Court of Appeal makes a wonderful thing this summer. They order a payment of a security by Romania in order, to secure the execution of the award in an event where Micula succeeds in their appeal in Luxembourg. This is impossible, but this is a formal pretext for the English courts to order the payment of the money. So security means that the money should be, and we talk, in this case, they ordered a payment of security at the level of 150 million British pounds. So 150 British pounds shall be transferred into the account of the court. of the British court. And as the Court of Appeal explains, a payment of this amount of money into the account of the court is not a payment of this money into the account of Micula. And therefore, it is not a breach of the prohibition to execute the award by the European Commission. However, in this manner, the British Court of Appeal, the English Court of Appeal, makes a clear message to the court in Luxembourg that they find it not fully reasonable, to annul all the BITs among member states of the European Union. And this is a clear message that there is a great probability that the British courts would not follow the decisions of the Luxembourg court. So we continue to observe the developments in the Micula case. I am sure that we will find much more interesting things later